With me here is Mike Nunn. Mike is with the Florence County Sheriff's Department. He is their general counsel. So he's got a little bit of a unique position here. He is both a licensed attorney and been through the police academy. So we're going to pair him up and we're going to walk through carrying firearms in South Carolina and what to expect from the police and what the police can and can't do in response to that. So we're going to dig a little bit into what you can carry, where you can carry it, and this is a great spot to bring up those questions about opening and carrying a rifle and what's allowable. The first question I would say we should ask is, what is the cause to stop? We've got a couple of things that could go on here. We got somebody perhaps walking down a road with a firearm in plain sight. That's an open carry situation. The gun might be the reason for the stop. That's going to be completely different where the firearm is concealed and is only discovered after the stop.
Yeah. I guess the issue is, what are we making the stop for? Is it solely because of the gun, or is there some other antecedent event that's caused us to have reasonable suspicion of a crime?
So when it comes to concealed carry, I would divide that into two spots. One of those is the stop is completely unrelated to the gun's discovered. The other one is the officer believes there's a concealed firearm there and stops for that reason. So what is open carry? Well, it's kind of what it sounds like. Generally, it's carrying the firearm out open where it can be seen, like most officers would do on their hips, but would also include a rifle or a shotgun slung over your shoulder. In South Carolina, that's a legal action. There's nothing that in state law says that you can't carry that rifle open. However, what we're not talking about with open carry is printing, which for those of you all who have used CWP and have taken that, you commonly know that's having a gun in a pocket or someplace else where the outline shows. Now, there's a bit of debate that Mike and I have between whether or not printing is concealed or not concealed.
Well, as a CWP instructor, I instruct my students that based on the law, concealed means concealed, meaning not seen. Well, if it's covered by a garment, but yet because of how the garment is either moved or how tight it is, or whether one reaches up to pick something off the shelf in the store, it causes the imprint of that weapon to be seen from the outside. Does that violate the law? And I tell them that an inadvertent print or exposure of the firearm probably will not get you charged with anything. I can't imagine a law enforcement officer doing that, but concealed under the statute does mean concealed, and that means not visible, not viewable from the outside, I believe.
The statute's a little lax. It says hidden from public view. What I would say is if y'all come into a case where that is the only charge, if somebody's got a printing of a firearm, that's the only thing they're being charged with, we'd both like to know that and see how the case goes, because we cannot imagine a situation where that is the only issue.
If that is what you're charged with, my guess is there's something else going on, and that was thrown on top.
So as we were discussing, generally in South Carolina, the carrying of weapons is allowed. The statute in question is 1623-460, and it says you cannot carry those weapons concealed. It is using the term weapons. That is a definition in there. It goes back to dirks, swords, rifles, shotguns. Does not include handguns. Handguns come under their own bit of jurisdiction that is prohibited against open and concealed carry.
That's right. All this regulatory scheme seems to focus almost exclusively on concealable weapons, which the Act defines as a weapon no less than 12 inches in length from its longest part.
The concealable weapon part, Mike, if I'm thinking correctly, is about the CWP. Outside the CWP, it's just a handgun.
That's correct.
Which gets back into what Mark Kelly was talking about. He has left us, where the AR-15 pistols, AK-47 pistols are handguns. They're much longer than 12 inches, so you couldn't carry them as a concealed weapon under your permit. However, you can only carry them still by the other laws of handguns. So how do you carry one of those loaded? Well, there are about 16 exceptions for when you can carry handguns without breaking that statute. Not many of those are actually allowed for loaded carry, but a couple of them are hunting and fishing, and then on your private property. So in South Carolina, if you're walking around your 100 acres of woods, you can put a pistol on your side wide open. Just don't step off to check the mail unless you're hunting.
I think it also includes on your employer's premises with permission of the employer from a fixed place of business.
It does, and if any of y'all go to an FFL, you'll notice about every one of them is going to be carrying openly. That's a common employment of that exceptions. Is it under his lease and control? Yes. There's a lot of gun shops you're going to find out that I can personally tell you they don't own the building, they are leasing it, but that does allow it because they are the holder of the premises. Now, does not work if they are just there as a guest from that standpoint. But then again, the business is a leaseholder. So when we talk about carrying a firearm, just to be clear here, there are other acts you can take while carrying a gun that raise their own concerns. If somebody points a gun, that's a completely different issue. A gentleman back here was talking about hunting from the road. If you are actually hunting from the road, loaded gun, that's going to become a different issue. So facts of the case will be paramount. If you're cruising down at 65 miles an hour, windows up, music blasting, and you've got a loaded shotgun next to you, that's probably a hard argument to make you're hunting from the road. If you're going at 10 miles an hour, windows down, music off, listening for the dogs, and the shotgun's got buckshot in it, that's a completely different argument.
And that's probably something that would be enforced exclusively by DNR and not routine police action.
Now, when you start digging into this, that's state law. There are a lot of localities, cities in this state that have different regulations. I know that Columbia and Charleston both have varying regulations on the carrying openly of firearms, rifles specifically, and what ammunition you can have, if they can be loaded, where you can carry it, and so forth. Arguably, none of that passes the preemption statute. And basically, that preemption statute print up there says that the localities, municipalities, the counties, and so forth cannot make law about where you carry firearms or ammunition. That has been recently actually an opinion point for the Attorney General. I'm sure everybody here remembers the Confederate flag hoopla of July. Some of you may realize that the Columbia City responded with a 1-month temporary prohibition on the carrying of firearms around the State House grounds. It's already illegal to carry a firearm on the State House grounds. That's defined as being inside the line of traffic on all 4 sides of the State House. The city came in and extended that and said, well, we're going to go with anything that's within 400 feet, 400 yards, I don't remember the exact distance, of that State House ground, thereby capturing the roadways around the State House grounds. So their actions purported to say, if you drive by the Capitol, you can't have a gun in your car. That was quickly brought up as a challenged question to the Attorney General. As you can imagine, with only 30 days in place, there wasn't a whole lot of time to actually bring a lawsuit. I don't think anybody was charged under the statute. The Attorney General basically, in a 5 to 10 page opinion reasoning through it, said that won't stand. He came down to 2 basic thoughts. One is a general principle. If the state government has made something legal, the local governments can't make it illegal. They can't take that area that's up under state government control and completely change it. And the other one is that the preemption language addressed it directly. Now, that's an Attorney General opinion. It's not case law. But I think it puts anybody who's challenging one of those local jurisdictions in pretty good standing.
I think that's exactly right. The legal rationale in that Attorney General's opinion is pretty much on point. I think the legislature has preempted that field, and it was intended to prevent the type of thing of a municipality coming up with a more restrictive gun law than the state has as a whole. They clearly established that their preemption of that field.
So keep that in mind, because those statutes do exist on the books. And there's potential for somebody in one of the big cities here to be charged with that. All right, we're going to play a couple different scenarios, just kind of walk through these. First one is Mr. John Doe here. He slung his AR-15 over his shoulder. We're going with an AR-15 because that is legal in South Carolina. He gets a neighbor that makes a call to the police. She's not used to somebody carrying an AR-15 over the shoulder, and I can imagine most of us have not seen that in our neighborhood. Anybody? So, what happens?
Well, it depends on the circumstance. Individual calls in to dispatch, says, hey, I'm worried about this guy walking down the street with an AR-15 slung across his back. It's really making me nervous. And that's it. There's nothing else. No, I just heard gunshots. I heard someone scream. He's running. Nothing else. Just an individual, by all appearance, lawfully walking down the street with a apparently legal weapon to carry in South Carolina. What's law enforcement's response? Well, I don't hear anything that would give me as a police officer reasonable, articulable suspicion that a crime is being committed. Now, it doesn't take much to tweak those facts to where I might have that reasonable, articulable suspicion, but based on the call alone, no. Change the facts a little bit. Again, individuals running, and I just heard gunfire. I heard somebody screaming, calling for help. Does that change the scenario? Yeah, it does. You know, I think it changes it tremendously, and I think a reasonable police officer under those facts and circumstances has the legal right to stop that individual and inquire about what he's been doing, where he's been.
So, Mike, what I'm hearing with you is we're looking up here at the numbers, that more than likely you're hearing 1, perhaps 2A, unless there's something else keying you off, in which case you may actually tell one of your officers to get out, stop, and do B.
Correct.
I'm guessing that C is not your normal instructions to your officers.
No, I don't think that would be a constitutional exercise of police power.
Well, good for us, somebody tried it. We'll get to that one in a second. So option A is the doing nothing. There's no laws that have been broken without more, as Mike's saying here. His accounts are peaceful. So, yes, that's the correct response, but it also kind of shows in the lack of the police officer side, or maybe they're not taking it seriously. So y'all are in a tough position there.
Well, we are. If there's something that's gone on before and we just can't detect it there, that's going to be on us. Although our response would be, look, if the people of South Carolina didn't want people to carry like this, then they should have asked their legislators to make it illegal, because otherwise, you know, it's not. Now, if during that encounter the police officer determines, based on his observation, training, and experience, this guy's really nervous, unnecessarily nervous. We know everybody's a little bit nervous after a police encounter. If that nervousness doesn't subside after a while, if the individual has a story that's all jacked up about where he's been, where he's going, you know, the other things, it's just indicators that would tend to suggest there's something else, maybe of a criminal nature going on here. You know, without more, or the individual making a furtive movement to the weapon against the instruction of the police officer, I just don't see where we've got a basis to go on.
Just to add to the hypothetical situation, based on some of the recent mass shootings, theater, you know, put that in the category shortly after those, a person or vice versa, perhaps here a terrorist. That would probably be that again.
Certainly, I think that changes the entire complexion of the situation.
Higher level of watchfulness part.
Correct.
I would attempt to clarify that and say perhaps it certainly brings up an awareness in that area near the time of the event. But a week later, 100 miles farther away, I would say that our constitutional rights aren't eroded by that full-blown action elsewhere that's completely outside of the government standpoint.
Agree.
So you're talking through the consensual stop, and I pulled that slide up here. Keep in mind, this is voluntary. If the police officer stops and says, "Hey, nice AR, I want to talk to you about why you're carrying it," the guy looks at him and goes, "I don't want to, have a nice day," and walks off, what can you do?
Well, again, unless we've got some articulable, reasonable suspicion of something else going on, I don't think we have the authority to extend that stop. It'd be like a street encounter with an individual walking down the street, doing nothing more than moving from place to place. Asking that individual for no reason for his identification, I don't think police have authorization to do that.
Well, let's say the police officer,
unless it's a voluntary thing. Hey,
right?
I'm Mike Nunn. I'm with the sheriff's office. I'd like to speak with you briefly today about X. I'm sorry, I'm not interested in having a conversation with the police today. Have a great day. Gotta let him go.
Well, let's step into C. That's the option that the officer goes from voluntary to involuntary. He's actually going to force this encounter. At this point, we're hitting an involuntary detainment. So you're looking at the requirements of Terry. I think most of us are probably familiar in some aspect with Terry. There has to be some articulable reason for that stop. Otherwise, it's an unconstitutional stop. And what has been addressed in a recent case where a gentleman's walking down the road with his gun, wife, and dog, an officer comes out the car without some more, puts a gun on him and says, "Get down, I'm disarming you," in a state where his actions were perfectly legal. The court addressing that came out very clear and said there's no automatic firearm exception to the Terry rule. So just the fact that the gun's present doesn't mean that you've satisfied the Terry standard. That still applies.
And I will say that that's not to minimize the concern of the public, that they see something unusual that bothers them. I get that. There are a lot of people who don't share our appreciation of firearms. They're extremely concerned and apprehensive about them. They can never be used for anything but evil or bad, and only bad people have them. And so we get that. But the law requires us to look beyond it. And if we don't have that reasonable, articulable suspicion, we don't have anything to create that involuntary detainment.
And the key there is the dangerousness. Now, we've established open carry, John Doe's armed, but is he dangerous? And if he's dangerous, then the Terry stop can kick in and the police can do something. If he's not dangerous, all they can tell him is have a nice day. Otherwise, as the courts have written opinions on it, this would erode the Fourth Amendment, and the 14th Amendment as applies it for persons who go out armed. And we can't pit one constitutional right against another. So you need that fact of dangerousness of criminal activity to do the disarmament. That's something to think in mind is if you were to go out and publicly armed, if you got a client who is, carrying a firearm publicly, whether it's based off he's going fishing and gets out and launched a boat, he's got a pistol on his side, or if he's just carrying a rifle from his house to a friend's house. Where it's permitted to happen, the police can't otherwise disarm them as a matter of course.
I agree.
All right, so we talked about concealed carry. That's our exact definition on the second point down there. A manner hidden from public view. We can certainly debate what is hidden from public view. Is that the reasonable person? Is that the person looking for it? Is that the trained eye? Mike's going to spot a gun that's printing much faster than the average soccer mom in Walmart, who might not know as if it's half hanging out the pocket. Additionally, there's been case law from other states all over the issue to the point that open carry can only mean an Army or Navy pistol carried in the hand. To, concealed carry or open carry is any little amount of buttstocks poking out of your pants. So from that standpoint, it's extremely hard to know what is open and what is concealed without specific state opinions on the fact. And we don't have any in South Carolina, which probably speaks as much as anything of this being a non-issue.
Pretty much. Unless you're carrying to a concealed weapons permit, you're you shouldn't be carrying, and that needs to be concealed. You go to a place like Nevada, it has open carry. You have to have a permit to conceal it. But as long as you're not prohibited from purchasing the weapon under either state or federal law in Nevada, you can wear it open in just about any place you want to go. Now, there's some areas where it is restricted, but you have to have a permit to conceal it. But if you have it concealed and you're wearing it concealed, you're supposed to keep it concealed.
The same applies here, where generally you can't carry a pistol openly. Now, let's say you have one of your officers. He's going down a street, crowded somewhere, and he noticed somebody who he believes is concealed carrying. He somehow detects it. Maybe it's not a clear print. Maybe it's just the way the fellow's favoring a particular leg. He thinks he has a concealed firearm. What can you do?
Well, unless we know, and I don't know how we would, that the individual does not possess a valid CWP, I'm not sure there's a lot we can do, because we can't just assume that the individual is carrying illegally when, with a permit, perfectly legal for them to do so. It'd be like stopping a vehicle to check to see if an individual had a valid driver's license. Well, unless we know that John Doe has his license suspended and we see him driving, we don't have the reason to stop. Now, if we know that an individual is either a convicted felon and is prohibited under law from possessing a firearm, or we know because of some prior run-in with law enforcement he's lost his CWP or it's been revoked, and we see evidence that he may be carrying in violation of that, then perhaps we do. But absent those other qualifiers, I don't think we do.
I think that's a good point to know. Is it just because you can tell something is there, the fact that it could be legal at other times and you don't know if those times are counting, the officer can't just bring it up. What some of the courts have compared this to, their particular argument is, it's like saying, I see somebody with a wallet, and I know that wallets might be used to hide counterfeit money, but that does not mean that we can take his wallet and search it for counterfeit money, because that's not the presumption. The presumption of activity is that it's legal. So I think that's an important point to note, that unless the officer has specific knowledge that what's happening is illegal, he recognizes them from his probation days, 2 years ago, you can't just stop and say, hey, I think you have a gun, where's your permit? So let's talk about the one that I get the most questions of, and that's, I get stopped in my car for some activity that's going to get me a ticket. Speeding, didn't stop for a red light, what have you. What can the officer do? Well, that car stop is a Terry stop. You are being involuntarily detained based off of a finding of some criminal activity, namely the traffic infringement. So an officer immediately is raised to the Terry standard. He has a lot more leeway.
That's right. If the police officer is making a traffic stop, he has to have, at a minimum, reasonable suspicion of a violation, preferably probable cause, because he's seen it. But reasonable suspicion at a minimum. And that's the reason that you're stopped, and that's an involuntary detainment once the blue lights get cut on.
Well, let's talk about the person who's behind the wheel. So he's been stopped. He's in a Terry stop, officer's walking up. What does he have to do? Well, if you got a CWP and you're carrying pursuant to the CWP, you have to notify the officer if he asks for your license. Now, if he walks up and he says, hey, we had one of these cars stopped in a bank robbery and we had 2 men driving it, and I see just you, little lady, you have a nice day, and walks off, you have to show him a CWP?
Not unless they perceive that I'm a police officer and I ask for their identification.
So in the instance he never asked for identification, you don't have to do it. But if he asks for identification and you're carrying that pistol pursuant to the CWP, you have to show that CWP. And if he asks where the pistol is, you have to tell him that too.
And that applies to passengers as well. Only when the passenger is asked for their identification and they're carrying pursuant to the CWP statute do they have to disclose that they are that they have a CWP, and then the process goes on from there. but ironically, you can carry in South Carolina in your vehicle without a concealed weapons permit if the weapon is in your glove box, in the center console, or I think that's pretty much it without the CWP. So I could have a CWP, have my weapon in the glove box, and I don't have to disclose it to the police officer because I'm not carrying it pursuant to the CWP statute. Now, I will tell you, as a police officer who's made traffic stops, when the person I've stopped tells me I've got a concealed weapons permit and I'm carrying a concealed weapon, my apprehension level goes down. Why is that? Well, even though there's a weapon in the vehicle, I know that this person, number one, is complying with the law by telling me they've got the permit. They've got a permit, they've been through the training in the class, and SLED has put them through a background check. The chances of that individual being a threat to law enforcement are almost statistically insignificant.
Or as Roy put it a little earlier, it's statistically less than the law enforcement committing a crime.
Exactly. So my apprehension level goes way, way down. And this stop is going to take on a whole nother attitude. Now, that doesn't mean I'm still going to let my guard completely down. But I'm going to ask the individual, are you carrying a weapon on you? Where's the weapon located in the vehicle? It's in the glove box, or I've got it concealed, or it's in my pocketbook, or it's in the side pocket over here. I'm just going to ask them, thank you for telling me. Please don't make any movement toward the weapon unless I instruct you to do otherwise. They comply with that, we're going to have a wonderful experience here. I'm going to write them a warning or a ticket, and we're all going to be on our way. Now, if the weapon is, let's say it's in the glove box, and they say, my license or registration, my registration, my vehicle's in. Well, I may or may not ask them to go get that. If I can run the tag through my computer, I don't need to see their registration. I know it's valid. And they've got their license on them right there. So we don't even have to go to the glove compartment. That way, we don't even have to worry about the weapon. If for some reason we have to go in the glove box, what I will typically do is ask them, I'll come around, I'll just ask them not to go in the glove box, but I may go around to the passenger side, open it up, get the registration out myself, and deal with it that way. But I'd prefer for the individual not to handle the weapon or bring it out while I'm there.
Which brings a very good point up. If you're not carrying pursuant to a CWP, regardless of whether or not you have one, you're asked for your registration. If it's sitting under the pistol, tell the officer before you reach in to get it. You may not be legally obligated to, but it's wise.
The last thing we want is to be surprised. We don't want to be surprised by a weapon in the vehicle.
Now, Mike, if you have somebody who's not carrying pursuant to a CWP and they have a firearm legally in the car, whether that's a shotgun behind the seat or a pistol in the glove box, and you ask, or one of your deputies asks, do you have a gun in the car? Does that person have any obligation to answer that question?
Probably not.
So he could tell you that's not relevant to this. I do not wish to disclose that information. And what can you do?
Well, sometimes you could ask them to step out of the vehicle. If they don't have the weapon on themselves and you want to remove them from the weapon, you can ask them to step out to the back of the vehicle while we finish this encounter. That way, we know it's not being accessed and it's no longer a threat to police officers.
And that's been held constitutional in Pennsylvania versus Mims and Maryland v. Wilson, also for your passengers. So the officer could ask everybody in the vehicle to step out and just walk to the back of it if you wanted. Now, it is theoretically possible the officer could disarm the person. They could take the gun with them when they go back to the car. I would say that doing that as a matter of course is going to be problematic, but if you see something that makes you think that this is a dangerous situation, I would say the officers probably can justify it.
And I've seen situations where the driver remains in the driver's seat, the officer takes the weapon out of the console of the glove box, puts it on the roof of the vehicle until that encounter's over, and then returns it back. That way, it's moved out of the situation where it can be accessed and nobody's going to be harmed by it. Yes, sir.
A lot of times, at least I would stop at a taillight at and if the officer might see what this person, she said, that weapon, because the console mate said, you hand it. I said, yeah. I said, like that. They said, I and then picked it up, handed it to her, and she said, you have a policy of taking possession of firearms during the stop.
That must be their policy, and I'm certain that it's based on some officer safety criteria. Personally, my preference is that the weapon not be handled at all on a traffic stop. That's just my personal approach, and I can tell you that Florence County Sheriff's Office has no such policy. Yes, sir. You mean like a traffic safety checkpoint for? Yeah, that's a traffic safety checkpoint which has been held constitutional by the Supreme Court. You stop every vehicle for a sobriety check. That is, courts have said, yes, that is a seizure under the Fourth Amendment, but properly handled, that encounter is so brief and so short-lived and limited that it is not an unreasonable seizure under the Fourth Amendment. But usually what you're asking for in a traffic safety checkpoint is license registration. Once that checks out, there's nothing else to indicate a problem. You move them on.
Typically, it's license registration.
Then I think that exceeds the bounds of constitutional stop. Now they're extending that. What are you doing? I'm riding on the public roadway. That's what I'm doing. Nothing wrong with that, is there? If it extends much beyond the license or registration, I think they're on very thin ice.
Mike, hasn't there been a case of that same type of stop system being used for drugs and being found unconstitutional?
Yeah, that's the Indianapolis case. They used one of the cases the Supreme Court looked at was in Indianapolis. They had an area of high drug traffic. So they set up a traffic safety checkpoint going into that neighborhood. And they had the drug dogs, and they had the narcotic units, and they had all this stuff, and they found a lot of drugs. And one individual challenged it, and the court agreed, saying that was an inappropriate use of traffic safety checkpoint because they weren't looking for driving under the influence. That was general criminal investigation, and they said that was improper. But the courts have ruled that driving under the influence, state has a particular interest in prohibiting and detecting driving under the influence, and so that these stops that are based on that are constitutionally permissible.
And on a humorous note, on one of those drug stops, they put the sign up about 50 to 100 yards in front of an exit and said, "Drug stop, next mile," and they put it off the exit. So they figured that everybody who was passing through without troubles would just keep on going, and everybody who exited, they'd get.
Those were the good old days. They don't let us do that anymore. Kind of like shooting over bait.
All right, so in Northrop, the government makes some arguments, and one of them is that it would be foolhardy for them to go in front of a citizens and conduct their business while allowing that citizen to be armed. And actually, that's in a Fourth Circuit case. I stand corrected. That was a United States versus Black. The general scenario of that case is the officer observes a man. He thinks he's suspiciously stopping too long at a gas station, follows him into an apartment complex where the guy is sitting around a campfire talking to half a dozen other people. The officers walk up for a voluntary encounter, and the man immediately points to his side where he has a pistol legally carried under North Carolina law in the open, and the police proceed to disarm him. They then put in what they refer to as their rule of two, where there's one gun, there's two. So they proceed to check the other 5 people there and discover a person illegally carrying a concealed firearm who also happens to be a felon. That's Mr. Black, who winds up carrying the suit to the Fourth Circuit. During that, the officers try to justify their disarmament of the person legally carrying a firearm as describing it as foolhardy for them to try to do their business with an armed citizen. And the court is not persuaded and makes a big point that the presence of a firearm is not reason enough to disarm the citizen. And they got to, look at the original reason for the stop and go back again, as we were talking in Northrop, for indica of dangerousness. Is the person armed and dangerous? So we can apply that back to the traffic stop here and say, if it's purely a speeding or you ran a red light, something I would call typical traffic infringement, I don't believe that routine seizure of a firearm is going to meet that level. So I believe that your local municipality there is walking on thin ice.
It raises another question. Let's say during the course of a traffic stop, whether with or without a CWP, if firearms being legally present in the vehicle, do I have the authority to check to see if that gun's stolen? In other words, can I radio back into dispatch and ask that the weapon be run through NCIC, see if it comes back hot? And I guess on a routine basis, probably not. But if I have some other suspicion that it might, that I can articulate, then perhaps I can run that check. What if I get the weapon and look at it, and there's a piece of tape over the serial number?
Do not remove without a warrant.
Well,
I've seen it.
Maybe. Do I have reasonable suspicion of criminal activity to justify my pulling the tape off? What if there's no serial number at all under there? That would make it illegal per se to possess, would it not?
Depends on the gun. Prior to the 1950s, serial numbers were not required. And as Mark would have told you, the federal laws incriminate new activity, not old. So I do have pistols that predate those laws that have not a serial number on them.
Yeah, but Glock didn't make any back.
If it was a Glock, then no, they didn't make any. If the serial number has been removed, it is a different matter.
So I think the jury may still be out on some of that, and it's all going to be so fact-dependent that it'd be hard to come down with the hard and fast, at least from my standpoint, rule on that. You can, you can't. I don't know. I don't think it's black and white. 18. The South Carolina Constitution says, except for the purchase of alcohol, you're adult for all purposes in South Carolina. In South Carolina at 18, you can purchase a firearm. Long gun and shotgun for sure. You can purchase a handgun from a private individual.
Mike, is there anything that actually prevents someone under 18 from having a rifle or shotgun? There's a law on pistols, but I'm thinking there's not a law on rifles and shotguns.
I think that's correct.
So I think from that standpoint, if you let your son go out into the woods at 15 with his hunting license with his own shotgun, I think he's okay.
Well, and there's even sort of an ambiguity with regard to that hunting and fishing thing, because it says that an individual can carry a handgun, either open or concealed, on their way to or from hunting or fishing if they are licensed. Well, you have to have a license at 16. Now, I'm not exactly sure how that would work out. but there's certainly an ambiguity there that someone might look at.
Could
Is
they
my
pick-
16-year-old son, could he carry a handgun open,
He can.
going to or from hunting or fishing?
There's another provision on the handguns that limits when underage can have them. So I would say we look there for that first. But the question you're applying is, what if he's with you? He can legally hunt without a license. Is that piggybacking on your license also piggyback on your right to carry open?
Well, I don't know. But if he's 16 or older, he's got his own license.
Let's ask the question I get more often. I'm getting ready to go hunting. I'm leaving my house at 4 o'clock in the morning, and I need to stop and get gas. If I've got the pistol already strapped to my side, can I just get out and put gas in the car?
The statute says directly going to or from.
Does it use the word directly in there?
I thought it did. Maybe not. We'll have to look and see. But if you're going to the Waffle House before or after, I don't think it applies there. I think you need to be going to or from. Yes, sir.
Those open carries are concealed in a automobile.
I don't think
You
so.
have a sidearm, and you're going to or from shooting hunt. If you're in an automobile, it's at a concealed weapon because it's not visible outside the automobile.
For the exception of hunting and fishing, it doesn't matter whether it's open or concealed. However, that is a good point from the question of, does it fall under your CWP now because you can't see it outside the vehicle?
I think the concealed part, although you can have it in the glove box and in the console, under the seat, or in any compartment inside the vehicle. I don't know. I don't know the answer to that. Good question. I know with the, I don't think with the CWP you can wear the weapon on your person open inside the vehicle. I don't think so.
I would still say it's hidden from public view. I mean, now if you got it up here on your shoulder, no.
I'll look for police on it.
I would make an argument on that one and wouldn't be afraid to take that to the jury that was open from public view, especially if the way you got out of the vehicle changed it back to concealed. You know, if you had a jacket over it, you walked up to your vehicle and to be comfortable, you took your jacket off, stepped in and closed the door, and when you come back out, you put the jacket back on. We can make a good argument. It's hidden from public view the entire time.
You couldn't leave it on the seat.
No, that's how you would carry North Carolina. That would make it open in their state, and that would be open in ours, I do believe.
So the question would be, if you can't carry it on the seat, but could you carry it openly on your hip? I don't know. Good question. Never heard that one being litigated. I don't want to be the test case.
Well, I get a question for that. Wow.
The safe answer is conceal it. If you got the CWP, wear it concealed. If you don't, put it in the glove box.
I tell a lot of my clients to, take it out, put it in the glove box, solely from the fact that if you get stopped, you now have the option on whether or not you're going to pull out that CWP. If you take a look at that officer walking up and you think, oh, this one's not going to like CWPs, this one's going to give me a hard time, you can go, I'm just going to skip that encounter. Now, I've got my registrations in a different place, I've got my gun in a different place, it's not presented CWP, I can just skip that whole procedure if I want.
You say if you got a CWP, put it under the seat.
Yes, sir.
But if you don't have a CWP, you got a regular pistol, you got to put it in the glove box. How does the police officer know the difference?
I believe the police officer sees it under the seat.
He gonna take the gun from you.
He's going to ask you if you have a permit.
And if you haven't disclosed the permit to them, you're probably going to get a ticket for not disclosing the permit.
That's right. You've already violated the CWP by not disclosing that you had one when he asked for your license registration and then inquired about where the weapon was located.
However, if you get stopped, you pull out that CWP and he asks you where your firearm is, and you tell him it's underneath the seat, in your pocket, in the bag next to you, and you got one in the door there, he might ask you to step out the car.
That's right. I'm less concerned about where it's located than the fact that it's been disclosed to me from the get-go.
So kind of a quick summary here. If you're going to carry, first off, be polite and be courteous. If you're just being mean to everybody, you're not going to get any benefits of the doubt. For consensual stops, I always take the view that no good can come from those. You're not going to get a pat on the back. You're not going to get a thank you letter from the police officer. The best thing you're going to do is only lose 5 minutes of your day. So I always say end them sooner than later. If it's involuntary, do everything you can to bring it to a close quickly. You know, if you're stopped on going to the store speeding and they pull you over, stay on topic, move it along, and don't delay it. Because if you delay it and the dog, you know, his buddy shows up with the dog while he's writing you a ticket, they can run it around the car and see if they're sniffed drugs. So that's one of bring it to a close quickly.
The interdiction stop is a topic for another day, which I'm glad to go off on at some other appropriate time. But there's a great way to, and we put this out, especially in light of certain recent events, is how to survive a traffic stop. You know, roll your window down, cut the radio off. You're smoking a cigarette, put it out. Put your hands on the steering wheel. If it's at night, cut on your dome light. And when the officer approaches, you know, just follow the instructions. Chances are we're simply there to investigate a routine matter, and the quicker we get down to that, the better off everyone's going to be. If there's a problem with the officer, the time is to redress that is not on the side of the road. It's to call a supervisor after everybody's left or file a complaint. If you want to tape the encounter with your cell phone, that's perfectly fine with us. We'll probably tape it too. And that usually resolves most of the issues. Our tape's usually going to show our officers complied what they're supposed to do when they work. If they don't, we want to know that too, because we want to correct that. Ladies or other individuals, if you are alone at night and the blue lights come on and it's a dark, lonely place and you feel uncomfortable, cut on your emergency flashers, reduce your speed, cut on your dome light, and drive to a place where you feel safe. Not a police officer around is going to hold that against you. You could also get on the phone and say, call 911. I'm being pulled by a police officer on such and such a road. Could you please tell him that I'm going to a place of safety? They'll be glad to do that. Most police officers are pretty reasonable folks. They've been down this road before. They just want to do their job, go home at the end of the day, and be with their family like everybody else. So we try and do that all within the constraints of the Constitution. Are we perfect? No, but we do the best we can. So any questions? Thank you all very much.
Thank you.